A Billy the Kid DNA test sounds like the kind of thing that should be simple. Take a sample, run the science, settle the argument. But what actually stopped it wasn't the lab. It was the legal system, court filings, cemetery authority, and a fight over who even had the right to dig or to see the evidence. And there's an even quieter battle most people miss. A records lawsuit that tried to force investigators to show what they'd already tested and what they claimed to have found. This story isn't about a Wild West shootout. It's about paperwork, power, and how a famous outlaw can still create real-world conflicts more than a century later. Number 1. The DNA question. A DNA test was supposed to answer one blunt question. Is the Billy the Kid buried in Fort Sumner, New Mexico, actually the same person the Old West records call William H. Bonney, also known as Henry McCarty? Or is the grave part of a story that got repeated so long it turned into truth without anyone checking the hard evidence? Most historians accept the standard version. Lincoln County Sheriff Pat Garrett, acting as a lawman, killed the outlaw in Fort Sumner in 1881, and the body was identified at the time and buried there. But the Wild West has a habit of producing second lives. For decades, men claimed the wrong person died, and that Billy lived on under another name. The best-known claimant was Ollie L. Brushy Bill Roberts, who said he was Billy and died in 1950 in Texas, and another name that kept coming up was John Miller, buried in Arizona. The DNA idea came from a modern angle. If you can match genetic material from a confirmed family line to a set of remains, you can cut through rumors with something that looks objective. That's why, in the early 2000s, local officials in New Mexico talked about using DNA not just to satisfy curiosity, but to settle a real argument about history, especially the claim that Garrett killed the wrong man and then covered it up. One of the officials involved said they wanted to clear up the rumors because Garrett's legacy is still tied to law enforcement identity in the area, not just to old cowboy stories. The tricky part is that DNA doesn't magically label a sample Billy the Kid. It only tells you whether two samples are related. So you need two things at the same time. A sample you can trust from a specific person or grave, and a comparison sample from someone who is a documented relative. Even the easy genetic routes are limited. Mitochondrial DNA, the type passed down through mothers, can connect people through a maternal line, but it usually can't pin down one individual if lots of people share the same maternal ancestry. Y chromosome DNA follows the father-to-son line, but it only works if you can identify and test a confirmed male line relative. And with old remains, contamination is always in the background. Soil, handling, and even earlier grave disturbance can mix genetic material. That's why the Billy the Kid DNA story quickly stopped being just a science question and turned into a legal question. Who gets to dig? What exactly would be dug up? And who has the authority to say, yes, that's the right sample to test? Number 2. The plan to dig. In October 2003, the DNA push didn't start with a TV network. It came from New Mexico officials tied to law enforcement, Lincoln County Sheriff Tom Sullivan, Deputy Sheriff Steve Sederwall, and Tobacco County Sheriff Gary Graves. They filed a court petition asking permission to exhume Billy's mother, Catherine Antrim, who they said was buried in Silver City. The basic game plan was to use family DNA first, because it's usually cleaner to start with a known relative than to gamble everything on a legendary grave. They wanted DNA from Antrim and planned to compare it to DNA linked to the main claimant, Brushy Bill Roberts, the man from Hyco, Texas, who insisted he was Billy until his death in 1950. Their attorney, Sherry Tippett, even framed it as a regional tug-of-war, joking that Texas already gets New Mexico's water and shouldn't get Billy too. The petition also leaned on practical reassurance. According to the filing, a state forensic anthropologist believed Antrim's remains could be exhumed without disturbing other graves. At the same time, Sullivan's group kept describing this as more than a publicity stunt. They said they were reopening a case tied to the last days of the outlaw, including questions around the 1881 jail escape and whether someone supplied a gun or helped set it up, and the fact that 2 deputies were killed during that escape. They talked about starting the exhumation quickly, aiming for mid-November if the court signed off. Another piece that often gets skipped is that the mother's DNA wasn't meant to stand alone. The idea was to build a chain. Get Antrim's DNA, then get DNA from the body under the Billy the Kid gravestone in Fort Sumner, and check whether the relationship fits a mother-son match. If they could locate other relatives, they even floated comparisons beyond that, like Billy's half-brother, Joseph Antrim. Even on paper, that approach needs multiple court permissions, multiple sites, and clean lab work at every step, so every link, mother's grave, Billy's grave, and any other relatives, could become the point where the whole effort stalls. Number 3. The people who said no. The first serious resistance didn't come from a lab. It came from the towns where the graves sit, and the officials responsible for them. In Fort Sumner, Mayor Raymond Lopez publicly attacked the exhumation idea. One report even quoted him calling the investigators 3 idiots, and coverage described the proposal as a threat to the town's main tourism draw, the Billy the Kid gravesite. In Silver City, local officials were also openly skeptical. A councilor, Steve May, called the exhumation a cheap publicity stunt, and he dismissed the criminal investigation label as nonsense. This wasn't just talk for the microphones. The mayors and town officials fought the requests in court, and opponents organized around the idea that the cemetery should stay as it is. A preservation group formed specifically to oppose the digging, arguing that disturbing the grave would damage a historic landmark for little more than headlines. There was also a money and reputation layer that's easy to miss. Fort Sumner is small, and the grave is famous, so locals worried that if DNA testing suggested the remains weren't Billy's, it could undercut the story the town has built decades of visitor traffic around. On the other side, the sheriffs were accused of chasing attention, and that accusation mattered because it shaped how judges and the public heard the criminal investigation argument. Even within the coverage, you can see the clash. Opponents framed exhumation as something that would change the feel of the cemetery with no clear public benefit, while the investigators framed it as clearing up an American Old West mystery that still affects how people see a famous lawman and a famous outlaw. Then there were the practical and forensic objections, which sound boring until you realize they can kill a DNA project all by themselves. People pointed out that old cemeteries aren't always stable. Markers move, records get messy, and graves can be affected by floods, construction, and reburials. If you can't say with confidence what remains are in a specific spot, then even a clean DNA profile can't answer the identity question, because you may have tested the wrong person. That concern wasn't hypothetical. A forensic anthropology text notes that a prior request decades earlier, back in 1962, was rejected by a New Mexico court on the reasoning that a search for Billy's remains would inevitably disturb the remains of other people buried nearby. And the opposition wasn't anonymous. Trish Saunders, described as a co-founder of a preservation society focused on Billy the Kid history, publicly celebrated the effort to stop the dig and called it a victory for common sense. By the time the legal fight got serious, even basic questions like who had standing to file the petition and who had authority over the cemetery became part of the resistance. Number 4. The court roadblocks. The legal system didn't give the investigators the simple yes they needed. In spring 2004, State District Judge Henry Quintero declined to grant the request to exhume Catherine Antrim, and his order laid out the core problem in plain terms. There was substantial uncertainty about recovering the kid's remains in the first place. The judge's message was basically, start with Billy, not the mother. Only if the petitioners could successfully locate Billy's burial site and collect his DNA, could they come back and ask again for the mother's exhumation, which is a big hurdle because it flips the logic of the original plan. Instead of using the mother as a stable reference, they now had to prove they could get a reliable sample from the most disputed grave in the story. Meanwhile, the Fort Sumner petition to exhume the body under the Billy the Kid headstone was moving through the 10th District Court system with months of back and forth. The conflict got big enough that New Mexico Governor Bill Richardson stepped into the narrative by appointing an attorney, Bill Robbins, to represent Billy the Kid's interests. Not the living claimants, but the dead outlaw himself. Robbins argued that genetic findings could matter for a posthumous pardon discussion, which shows how tangled this got. DNA testing wasn't just about history, it was being used as leverage in a legal reputation argument. Then, in a turn that surprises people when they hear it, the Fort Sumner case ended not with a dramatic ruling, but with a quiet filing. A report at the time said the petitioners dropped the case with prejudice, meaning that particular petition couldn't simply be filed again, and a scheduled hearing before District Judge Ted Hartley was cancelled. The same report said the court documents did not spell out why the case was dropped, and the town's attorney said it happened through pre-hearing negotiations, while also noting that the investigators were working with forensic material like alleged bloodstains from a bench. From the outside, this is what stopped the DNA test really looks like. No single courtroom moment where a judge declares the science forbidden, but a stack of legal hurdles, uncertain remains, contested authority, and strategic withdrawals that shut down the cleanest path to a definitive answer. Number 5. Trying to solve it without the grave. Once the exhumation route stalled, the investigation leaned on other physical evidence tied to the Billy the Kid story. One item that kept coming up was a carpenter's bench associated with Fort Sumner, said to have bloodstains from when Billy's body was placed there after he was killed. The forensic name connected to that work was Dr. Henry Lee, and later court records fights show that people wanted his DNA analysis of that alleged blood evidence. Even if you ignore the politics, evidence like an old stain is scientifically hard to use. You need to know the stain is real blood, that it belongs to one person, that it hasn't been contaminated, and that it's tied to the historical event the way people claim. If any of those steps are shaky, a lab result can look precise while still answering the wrong question. The investigators also took another route that sounds bold but created its own problems. In May 2005, bones and teeth were taken from the grave of John Miller in Prescott, Arizona, after a claim that Miller was Billy the Kid. Prosecutors later decided not to file criminal charges in connection with that disinterment, and the story immediately became controversial because it raised questions about permission and process. The stated scientific point was comparison. Reports said the DNA samples were sent to a lab in Dallas to be compared with blood traces from old artifacts, including the bench in Fort Sumner, where Billy's body was allegedly placed. But even this no new digging in Fort Sumner approach still runs into the same core issues. A match between Miller and a stain doesn't automatically prove Miller was Billy. It only suggests a relationship between Miller and whatever person contributed that stain. And if the stain itself can't be solidly tied to Billy, then the comparison becomes circular. People believe the stain is Billy's because it matches the claimant, and they believe the claimant because it matches the stain. That's why this part of the story often ends with silence. In one report, Sadowul refused to say what the DNA tests showed. When results aren't public, the debate doesn't end. It just turns into a confidence game, where different sides claim the science supports them. Number 6. The records lawsuit nobody talks about. The quieter court fight wasn't about shovels in Fort Sumner or Silver City. It was about paperwork, reports, and whether a cold case investigation tied to a sheriff's office can be treated like a private hobby when someone asks for records. In 2007, writer and amateur historian Gail Cooper sued under New Mexico's Inspection of Public Records Act, along with the Tobacco County News, seeking documents connected to the Billy the Kid investigation, including material tied to DNA analysis by Dr. Henry Lee and reports connected to people who claimed they were Billy. The suit named Lincoln County Sheriff Rick Verdon and also targeted the officials who opened the investigation, including Sullivan and Sadowul. A key argument from the defense side was that the investigation was done as private citizens, not as sheriff's office officials, and therefore the records weren't subject to public records law. The court didn't buy that framing. According to an AP report on the case, 13th Judicial District Court Judge George Eichwald entered an order finding that Sullivan and Sadowul were acting as employees or agents of the sheriff at the relevant times, and that the sheriff opened and continued the investigation that was the subject of the lawsuit. After years of fighting, Lincoln County paid significant attorney fees in connection with the open records case, $125,000 to a newspaper's attorneys, with additional payments reported to other firms. This matters for the Billy the Kid DNA story, because it shows another way the testing effort was effectively stopped or slowed. Even when DNA work was being discussed and reportedly performed on artifacts, the paper trail became a legal battleground, and the public couldn't easily see what was done, what the lab said, or how reliable the samples were. Put together with the earlier court blocks on exhumation and the Fort Sumner case being dropped with prejudice, the obstacle wasn't one villain in a black hat. It was a system. Towns protecting cemeteries, judges demanding a reliable starting point, investigators shifting strategies, and record keeping that turned into litigation. A clean, definitive Billy the Kid DNA test would still require the same basics the courts kept circling back to. Identifying a specific set of remains or artifacts with a trustworthy chain of custody, and a comparison sample from a documented relative, before any lab result could mean more than another argument.